caught up to it. Oh, there it is. It wasn't really that nice. She's pretty busy. And now somehow we're and so I was texting her and I was like, looks like they're saying Friday, there's another trip. Do you have any airline miles you need to use? Oh, yeah. I'm going to call for meeting starting tomorrow morning at 9. So, and I want to see thanks.
Specifically, other, not.
Well, I was like, yes.
No, but yes.
Yeah.
I said legislative monitoring.
Oh, yeah, you did.
And whatever legal analysis and legislation, I don't want to. I still feel like I have a message.
Yes. Oh, okay.
So if there's a new test,
You would have to. What about?
I know. I've said on no, she's great. And I don't know if she's gonna say it.
You're standing a lot in policy development.
Yeah.
I was like this
Talk right into it. Hold it down here. All right, well, this is the 2-minute warning. Everyone quieted down real good. You're well practiced at this. I can see everyone knows how this is going to work. So thank you so much. Like I said, we're going to start exactly 10 seconds after 7 o'clock. We'll give all our stations just a quick second to connect, and then we will be live on the air across the state of Montana. So we'll kind of introduce things for the radio audience and the YouTube audience that's going to be joining us, and then we'll get started here. So we've got about a minute and a half before we get going. So this is literally your last warning. We'll be right back with you. All right, 15 seconds. Welcome to the 2024 Montana Supreme Court Candidate Forum, sponsored by the Yellowstone County Farm Bureau and Montana Farm Bureau PAC. I'm Coulter Brown for the Northern Ag Network, excited to be here with you tonight. Now, Montana Farm Bureau is the state's largest general agricultural organization, serving nearly 20,000 member families. Members raise a wide variety of crops and livestock on public and private lands, while serving as frontline advocates for issues critical to agriculture and rural America. We're coming to you live from the Billings Hotel and Convention Center and excited to welcome communities from across the state who are joining us on the radio. This forum is being broadcast statewide thanks to affiliate radio stations of the Northern Ag and Northern News Networks. We thank our local radio stations who are enabling listeners to take part in this discussion. So, well, we've got about 60 people in the room here in Billings. Thousands more are listening from Plentywood to Dillon, Miles City to Shelby. We appreciate you being here tonight, and we certainly appreciate Montana Farm Bureau for offering this forum. It's an excellent opportunity for voters to hear directly from the candidates on issues important to Montana's judicial system, with particular focus on agriculture and rural communities. We've got a lot to cover here in the next hour, so without further ado, I'm going to introduce our moderator for this evening, Casey Mott. Casey is the District 4 Director for the Montana Farm Bureau Federation, representing Sweetgrass, Carbon, Stillwater, Yellowstone, and Bighorn counties. He and his wife, Rebecca, ranch near Custer, Montana. Casey, I'll turn it over to you. Thanks for moderating this evening.
Thank you very much, Coulter. And now, without further ado, I want to thank you and the Northern Ag Network for your efforts to help us connect with rural voters. We're pleased to present the candidates for the Montana Supreme Court. All the candidates were invited. Unfortunately, Judge Lynch had an unexpected conflict and is not able to join us tonight. Joining us tonight for the position of Chief Justice is Corey Swanson. For the role of Supreme Court Seat 3, we have Judge Catherine Bettigary and Judge Mike Wilson.
Mike's my brother.
Well, I'm sure he'd do a good job too. Judge Mike Wilson, I'm sorry about that. You know, you cannot trust what you read. So after the second time, we all know who he is now. Thank you all for being with us this evening. The candidates will have an opportunity to introduce themselves, and then will be given 2 questions to discuss, for which they'll each have an equal amount of time to respond. The topics were selected by Farm Bureau members as they are important to agriculture and rural areas across Montana. Okay, so for Chief Justice, we'll start with Corey Swanson. If you want to introduce yourself.
Well, thank you very much, Casey, and thank you, Coulter, as well. I grew up listening to your dad on the radio, and boy, you sound a lot like him. I want to thank you all for coming, and thank you to the Montana Farm Bureau for doing this event. I'm Corey Swanson. I'm the Broadwater County Attorney in Townsend, Montana. I'm in my 10th year as a county attorney. Previously, I worked for Tim Fox when he was Montana Attorney General for 2 years, and I was in a private law firm in Helena, Montana before that. And in addition, or kind of alongside my legal career, I've had a fairly long career in the Montana National Guard. I'm in my 27th year doing that, and I've had my legal career interrupted a few different times for deployments overseas, but I've been honored to serve in the 163rd Infantry for most of my career, and very honored to lead some of those men and women across the world doing, I think, exciting and sometimes dangerous and sometimes boring missions. I'm running for the Supreme Court because I believe we need to depoliticize the discussion and the focus and the process for the Supreme Court to make decisions on cases. There's a lot of cases, and you'll hear more about this, there's a lot of cases before the Supreme Court every year that have nothing to do with politics. And my view is simply that the way that the justices decide those cases should be the same way they decide the most politically controversial cases, and that is simply remove politics from your considerations. The job of a justice is to correctly interpret the law and apply it to the facts of that individual case, and that's where it should start, and that's where it should end. So that's very much what I would like to do. I believe doing so will reduce some of the political tension that we have in the state of Montana and Helena right now. And really what we all want is we want a fair and impartial Supreme Court that can give us a reliable, clear, dependable law that we can all organize our lives around. Thank you.
All right. Thank you, Corey. For Associate Justice, we'll now turn to Judge Wilson.
Thank you, Farm Bureau, for hosting this event. It's great to look out into this room and see so many familiar and friendly faces. I'm Judge Dan Wilson from Kalispell. I'm in my 2nd term as a district court judge there. And when I decided to run for the Supreme Court, it wasn't because I had chosen an opponent. I wasn't aware that Judge Bidegary also intended to run until sometime later. The focus of my campaign from the beginning has not been to attack my opponent, but merely to offer myself, my experience, and my record as a qualified candidate for the Montana Supreme Court. And what I learned along the way is that there are a great number of special interest groups who have a keen interest in the outcome of these races. And they approached me at various times and asked me to endorse their sort of politicized view of the law. And when I was asked to do that, I refused. And I have stuck to my message throughout the campaign, which is I am here as a humble servant of the law. I am here to obey the Constitution as opposed to put my own unique spin on it. And I'm not here to carry water for any special interest group or party. And when you have that consistent message, you don't necessarily make a lot of friends among the elite special interests. And so what I discovered is that this wasn't so much for me a race to gain endorsements from special interests, but to have special interests seek my endorsement of their agenda. And having steadfastly refused to do that, I find myself in the rather unenviable position of probably getting more attack ads 3-to-1 than the positive message that my campaign fundraising has been able to fund. But hopefully the message is getting out. Judge Dan Wilson is here as a servant of the law, as a student of the law, one who is not there for his own personal agenda. And thank you.
Thank you, Judge Wilson. Next, we'll go to Judge Bidegary.
Thank you. My roots run deep in Montana. I was born, raised, and educated in Montana. I've carried my Montana roots that were in part formed by listening to the Northern Ag Network, beginning with Conrad Burns. Together with their father, in addition to my having been raised on a farm and ranch in eastern Montana, we raised 5 children on our farm and ranch in eastern Montana. While I practiced law for about 14 years, representing mostly hardworking farmers and ranchers, teachers, small business owners, and workers. For the last 21 and a half years, 21 and 3/4, I guess now, I have served as a district court judge for the Montana 7th Judicial District, which encompasses Dawson, Macomb, Prairie, Richland, and Webo counties. I'm running for the Montana Supreme Court because our state needs experienced justices who are fair and impartial to preserve our democracy for current and future generations. Growing up in agriculture taught me the value of hard work and perseverance, qualities that I bring to the judiciary. Over the course of my 39-year legal career, including more than 2 decades as a district court judge, I have handled a wide range of legal matters in about 40 of Montana's 56 counties, which has helped me hone my analysis, listening, and writing skills, which are all necessary to the appellate bench. Throughout my career, I have remained steadfast in my commitment to upholding the rights that are guaranteed to each of us by the Montana Constitution and the United States Constitution, especially protections for privacy, education, public lands and waters, and a clean environment. We know as farmers and ranchers that you don't kill the goose that lays the golden egg. If elected, I will continue to prioritize fairness and impartiality, keeping politics out of the courtroom, and ensure that all Montanans receive equal treatment under the law.
Thank you, Judge Bettigary. Now we'll go into the questions. The order of the responses was drawn ahead of time. Each candidate will have 3 minutes to answer each question. About 1/3 of Montana is public land, which is a combination of federal and state. Most of the federal land is enjoyed by a variety of users, including ranchers who lease it for grazing purposes as designated by the Taylor Grazing Act. This can be a great partnership, providing economic opportunities for farmers and ranchers and critical care for the land in noxious weed and grazing management. Recent federal rule making threatens to upset the balance. American Farm Bureau and others are suing the Bureau of Land Management, challenging the agency's recent decision regarding the addition of conservation as a designated multiple use, putting it on equal footing with existing multiple uses designated by the FLPMA. This would allow BLM to be leased out for conservation, potentially leaving lands idle and disregarding the economic opportunities and longstanding partnerships with agriculture and other recognized multiple uses such as recreation and mining. Montana Farm Bureau Federation and Phillips County Farm Bureau have also been granted the right to intervene in 3 appeals challenging the Bureau of Land Management's final decision on requested changes to the grazing permits that allow the American Prairie to graze bison on several grazing allotments in Phillips County. Montana Farm Bureau Federation argued that the BLM's decision regarding American Prairie grazing wild bison and conservation as a use is not in compliance with the Taylor Grazing Act or its implementing regulations. Taylor Grazing Act was intended to manage public lands in the interest of the livestock industry, the public, and ranchers. The BLM must consider the socioeconomic impacts of its grazing decisions. BLM's socioeconomic analysis is materially flawed because the American Prairie's bison herd and conservation as a use do not contribute to local economies in a meaningful way. While these are federal issues, conservation is an important value in Montana, not only for the public, for the generational agriculturalists. The question is, how would you work to ensure that Montana farmers and ranchers are recognized for their contributions to conservation and protected in their ability to help care for public land in Montana? You'll have 3 minutes to respond. We'll first start with Corey Swanson.
Well, your question is correct that is primarily a federal issue. So when you talk about the Taylor Grazing Act, BLM management, that's a federal statute, and those are federal land management issues. So I understand that litigation is happening, but it's going to happen through the federal system. So in the Montana Supreme Court is going to have very little to do with that particular issue. because it will be decided by a federal court. So my background when I was in private practice, I represented an organization called Citizens for Balanced Use, and we advocated for all those things, the multiple use on public lands, on federal lands, and respecting private property in the process. And when we come to how Montana Supreme Court may be involved in that, the first thing you have to remember is that those decisions, those policy decisions, will primarily be made at the legislative level. So when it comes to the court's review of those issues, as I talked about in my introduction, our job is to review and interpret the law correctly and based on the facts that are from that case, or to give the appropriate deference to a legislative statute. So the first thing I would say is the court needs to do its job and not inject its opinions into how those lands may be managed. It's up to the policymakers to do that. Second, what's important to the court is to correctly interpret them and not have a an anti-agriculture, anti-multiple use bias, because the policy needs to be established by the legislature. There is obviously an important part of managing state lands that are part of the school trust, that it has to meet its constitutional mandate for how you maximize the benefit from any school land or school trust land in order to go to the beneficiaries. But the other thing you have to keep in mind is that this is a fodder for a lot of the political attacks back and forth, and you always have to look through the attacks that Judge Wilson was talking about and to the truth of the matter. So I've been accused falsely by a number of these liberal special interest groups saying I'm against stream access or I'm against public lands access, and the exact opposite is the truth. I advocated to strengthen stream access in 2009 and got some amendments to improve a stream access bill that Governor Bullock actually signed into law. So if there's folks out there that are accusing me of being against public lands or against stream access, the exact opposite is true. Not only did I do that at the legislature, but then as a county attorney, I represented our conservation district and there was a case that went to the Supreme Court and I won at the Supreme Court. It was called Fortner versus Broadwater Conservation District. And in that case, I strengthened protections for streams by correctly applying the law that basically said you can't destroy a stream so much that it's unrecognizable and therefore avoid the regulations that go into that. So my record has been advocating for multiple use and responsible use in public lands, but that policy needs to start at the legislature. That's not the court's job to set that policy.
Well, thank you, Mr. Swanson. Next, we'll go to Judge Wilson.
Our Montana Constitution has a number of rights in it, and not all of them are in concert. They are sometimes competing or in conflict. There is the constitutional right to a clean and healthful environment. There's also a constitutionally protected right to own and possess and use property, and also the right to make a living. And to the extent that these various constitutional rights come into conflict in a particular case, it's vital and important that the justices on the Supreme Court are ready and equipped to take a good, hard, honest look about what was the debate surrounding the adoption of these various constitutional rights and what is therefore the proper balancing between them. We should not assume that because a constitutional right is enshrined in the Constitution, that it is somehow the jewel in the crown. There are a number of constitutional rights in our Constitution, none of which enjoys any sort of priority or primacy over the others. I've been to a number of these forums, I've been to a number of these debates in the course of this campaign, and I hear mentioned so often the right to privacy, the right to a clean and healthful environment, and so forth, but no one ever mentions the right to own and possess and put to productive use private property. No one seems to mention that there is a right to make a living, and I've never heard yet anyone mention, and so I'll just say it now so that the novelty somehow doesn't wear off. We also have a right to keep and bear arms under our Constitution, and that has and deserves every bit as much recognition and protection as any other. But to the extent that these conflicting uses come about to the attention of the Supreme Court in the context of a case, It will be the solemn duty of the Supreme Court, and I would take this very seriously if I were elected, to balance the various apparently conflicting constitutional rights so that none gets short shrift, including the right to own and possess and make productive use of property.
Thank you, Judge Wilson. Judge Gary.
The question that was raised, or the way that it was framed, is that it does invoke federal law. And so the particular issue would be addressed, as Mr. Swanson said, at the federal level, and would most likely not invoke Supreme Court involvement. Nonetheless, one of the things I know from having been raised on a farm and raised in a ranch and raised my 5 kids on the same place is how hard it is for farmers and ranchers to make a living, and how laws can maybe interfere with their ability to make a living. Even though I know these things, though, any case that would come before me on the Supreme Court that might raise an issue of the competing rights would be ones where I couldn't invoke into the record what I personally know about an agricultural lifestyle. I would have to make my decisions based upon those facts that are actually put into the record, that are relevant to the issue that is to be addressed, and decide that issue based upon the established law and precedent, because it is only by having judges follow the established law that we can have any kind of stability and certainty in our analysis of different issues that might arise. And it's the only way we can improve the opportunity for resolving issues. Farmers and ranchers are usually the frontline stewards of our land. They know that they make their livelihood off of that land. And so these competing rights that we have in our Montana Constitution to own private property, but also to protect our environment, are ones that would be addressed very carefully and analyzed very carefully so as not to prevent a livelihood, but also to keep in mind that we do need to preserve our land and have sustainable farming and ranching methods that will allow our future generations, young farmers and young ranchers, to continue to farm and ranch in our state. And so my commitment on deciding any issue that would relate to the conservation efforts would be to decide the case with an open mind, listen to the arguments that are actually made, consider just those facts that are relevant, not consider things that I know outside of the record just because I have a farming and ranching background, and make the decision based on the established law.
Thank you, Judge Bettigary. And thank you all for your thoughtful answers. The next topic is another critical resource, water. As Montana population continues to grow, our resources such as water are being strained, creating challenging situations for growing communities and irrigators. Montana is a prior appropriation doctrine state, meaning our water rights are determined by a practice of first in time, first in right. Of course, it is also recognized in this state that ground and surface water are connected, so every new use has the potential to impact an existing user in the same basin. Water rights are of the utmost importance to Montana farmers and ranchers because without water, we will literally lose our family businesses. The question is, what is your background regarding water law, and what would you say are the fundamental elements of Montana water law that will guide how water is distributed into the future? Once again, you have 3 minutes to respond, and we will start once again with Corey Swanson.
Well, when I was in private practice, I did water law, and then when I worked at the Department of Justice, I was heavily involved in the Montana versus Wyoming water law case that was before a special master of the United States Supreme Court. And the whole issue there was we have a basin that begins in Wyoming and then flows into Montana, the Tongue River, which then flows into the Yellowstone and then flows into the Missouri. And how does Montana enforce a call on water that's being held up in reservoirs in Wyoming that needs to be released for users? So I was heavily involved in that, and I followed these issues a lot. And I guess I think when we talk about the future of water law in Montana, we need to talk about three things. One of these is not from an opinion like on a legal opinion, but more the role of the Chief Justice, which is how do we address the current water court? There's proposals out there right now for the water court to remain and to shift from an adjudication to an enforcement court, rather than enforcement being done in each district court based on petitions from water right holders. I don't know the right answer there. I think you basically have a trade-off of people who are worried about statewide control from the water court in Montana versus trusting district court judges who don't have the time or the specialty expertise to handle that. And that's going to be a policy decision, but it'll be my job to represent the interests of the judicial branch as well as the interests of the water right holders, and to talk about things like how much it's going to cost and how is it going to work. And sometimes it's going to have to be an emergency responsive thing on a weekend in late July when you're trying to irrigate. So that's going to be a very important issue going forward for everyone that has water rights in the state of Montana. Secondly, when you talk about attributes of water going forward, you've got two things to keep in mind. You have scarcity and you have recognition that water is a commodity, okay? And the current DNRC policy for years has been very resistant to the idea that someone that has a water right can commercialize that water. I mean, they did it for a number of years in eastern Montana because of the water with the Bakken and the fracking and the high volume, right? But that was a difficult process they finally made it work. But when you apply that same concept to everyone that has water rights in the state of Montana, it really comes down to this. If you have water, especially if you have a senior water right, you're holding on to a very, very valuable commodity. I think that the water right community is going to want to have the opportunity to change the use, to lease it, to market it in some way. That's going to have to be a policy decision from the legislature. But that, in my view, I look forward to population growth, increased demands in the state of Montana. That, I think, is a big issue that this state needs to grapple with. The court, like I talked about the last thing, will be interpreting that policy, and I have a good background to be able to do that, but the policymakers are going to have to lead that discussion.
Thank you, Mr. Swanson.
Judge Bettigary?
I have an extensive experience with water law. When I was a first-year law student, my dad had previously seeded one of our dams with bass, and a little tiny piece of it was into our neighbor's land. And all of a sudden, the neighbor was irrigating out of the dam and drained it and killed all the bass. And that's when I learned about the prior appropriation and first in time, first in right, because our neighbor had gone and gotten a water right to be able to use that little point, that little piece of the dam, 98% of which was on our land, to be able to tap into the water in the dam. So I took a water rights class. And water rights has been important to me the whole time that I've been an attorney in 39 years and 21 3/4 years as a district court judge. One of the first cases I handled was an irrigator in Dawson County near Glendive whose neighbor had blocked his access to his irrigation. Because I was able to establish that my client had priority for the water right, we were able to prevail and get the neighbors to stop blocking his access to irrigation. That client is now a Dawson County Commissioner. As a judge, I have handled a number of different cases involving water rights and addressing what the priority of first in time, first in right. And so I do think that district court judges can be well equipped to address water rights issues. As we go forward, it's true that as our state grows, maintaining fair water access while considering environmental concerns is going to be critical. And so these issues are probably going to come up because we can see like the Milk River is dry. I mean, there are issues all across the state where we are fighting about water. Our water court continues to adjudicate the water rights in all of the basins across Montana. They are a little behind doing it, but they're still working toward it. As far as those that have been adjudicated, district court judges are well prepared to address them. And as a Supreme Court Justice, I would have experience both as a practitioner practicing law and water rights and as a judge adjudicating issues involving water rights that I could carry with me to the Supreme Court to understand the arguments being made on any issue involving water.
Thank you, Judge Bettigary. Judge Wilson.
Our Constitution may be relatively unique in the respect that in June of 1973, when adopted and when enacted, declared that essentially all of the water that can be found under the ground, on the surface, or even in the air above Montana is the property of the state. And there are these various agencies that are primarily involved in administering those rights, but when we own a water right in Montana, we don't actually own the water itself. We own the right to use it and put it to use. And the various agencies that have a say in how that policy gets carried out include the DNRC, which is primarily a record-keeping function, but the Attorney General also has a role in it, and so do two legislative committees, and the district courts and the water courts. And the district courts are there to provide backup for disputes once these water rights have been adjudicated. The long and short of it is that water is always going to be, in Montana under our current constitution, in my view, primarily a political question. And so those who have interests in how water is managed, how water rights are construed and enforced, are going to find themselves more often in the legislature, perhaps, than in the courts when it comes to set policy and when it comes to an issue like water that affects everyone, but probably none more so than the agricultural community. Then your efforts are going to be best applied, in my view, through legislative and rulemaking processes. That being said, my experience in water law, just like every other student of law in Montana who studied for the bar here, I studied water law, and I'm presently one of 4 district court judges in the state who is appointed to be the designated district court judge having jurisdiction over a particular water basin. Mine happens to be the Clark Fork River Basin.
Thank you, Judge Wilson. And thank you all for your answers. Next question. A petition filed by the Montana Environmental Information Center, along with 41 other groups, directs the Public Service Commission to consider social cost of greenhouse gases into rates for electric and natural gas service, effectively creating a carbon tax. This was spurred by a successful district court ruling regarding greenhouse gas emissions. The Montana Farm Bureau is actively opposing this action as the effects on rural utility rates and input costs would be detrimental to our membership. This is a prime example of extreme environmental policy precipitating from court cases. The question is, how would you balance the right to a clean and healthful environment with Montanans' freedom and financial stability? Once again, you have 3 minutes, and now we will start with Judge Wilson.
Again, it's important to acknowledge when anytime a court, district court, or Supreme Court applies the Montana Constitution, that we acknowledge that there is not simply one right at stake when it comes to these issues that impact stakeholders very differently. There is a right to a clean and healthful environment, and that is stated in the enumeration of individual rights in our Constitution, but it also is restated and balanced in Article 9 of our Constitution, which restates again that there is a right to a clean and healthful environment. And it also provides that it's the legislature's role to enact legislation to enforce that act. And so there is not a simple or clean analysis. You can't simply say, I think in good faith to the language of the Constitution, that one aspect of that right must trump over all of other considerations, and the other considerations must be taken into account. Our Supreme Court has had occasion, because the cases that have been brought before it concerning the right to a clean and healthful environment have been brought by private individuals asking the court to construe and apply that right as to how that right impacts individual conduct or a particular statute. But there has not been, to my knowledge, much litigation, which has raised the question of what is the proper role? What is the scope of the legislature's authority in determining how that right is to be enforced? And so to have the conversation about the right without first acknowledging that the legislature has an enumerated and express role in the Constitution to enforce that right to a clean and healthful environment, and nothing in the Constitution says it's reserved solely to the Supreme Court to decide how that right is enforced. I think any balanced approach, any balanced analysis by any judge or court has to first acknowledge that there are these competing authorities, rights, concerns, and there's not a simple or easy answer, or it's not appropriate to say that one right is superior to all other interests set out in the Constitution.
Thank you, Judge Wilson. Next, we'll go to Corey Swanson.
So thank you. I want to pick up where Judge Wilson left off. So you look at the Montana Constitution and its structure. So Article 1 is kind of the general structure of the government. Article 2 is the inalienable or the fundamental rights for Montanans. Okay, so there's a preambular kind of paragraph in Article 2, and then it starts going through all the different sections. So all your fundamental rights, free speech, right to jury trial, etc. They're all in specific delineated sections within Article 2. But the overall introductory portion of Article 2 is where it mentions what Judge Wilson is talking about. It includes various rights, right to make a living, right to own property, right to clean, healthful environment. And they're all written in such a way, structurally it's different than the individually enumerated rights in the sections below. And they're all written in a way, in some kind of a collective grouping. Structurally, they must have had a reason why they did that. I personally can't tell you today why, but it's certainly an issue for further research. But it does make you wonder whether there's an expectation that there's more policy making to be done by, for example, the legislature or somebody else rather than the Supreme Court. In general, the Supreme Court shouldn't be making policy. It should be the policy making entities. I don't know that I want to talk about this particular PSC issue. Number one, I don't know anything about it. And number two, it could come up for review in front of the Montana Supreme Court. But I will say this. If litigants are trying to make policy through litigation rather than through the policy-making organs of the government, I'm a little concerned about that. I talked at the beginning of how we want to depoliticize the courts. That includes courts shouldn't be in a place, and we don't want to be put in a place where we're making policy, enacting or changing policy through cases. There's sometimes it's unavoidable, but one of the ways that you avoid that is you do a very narrow decision that decides the controversy between the two parties that are in front of you, and that's it. You do it narrowly, you give a holding, and you move on. You don't take that occasion to go beyond the holding and make broad statements on policy or constitutional issues that weren't actually brought to you in that case. You will also see there's a thing called standing. Standing is the ability of someone to actually bring a case. They have to have some kind of injury caused by whoever is the person they're challenging, and the court has to have the ability to grant them redress in that case. I think that if you look at Montana Supreme Court standing doctrine compared to the United States Supreme Court or others, it's really expansive. And people have been abusing that to try and make policy by basically jumping in and doing theoretical cases and theoretical challenges. And my view will be, we need to enforce standing, and we need to decide cases narrowly on the issue presented so that we don't become a policy-making body.
Okay, thank you, Mr. Swanson. Judge Bittigary?
When issues are raised to the Montana Supreme Court, the Montana Supreme Court doesn't have the option to disregard it. So if the motives behind somebody raising a case is to try to develop policy, the Supreme Court can't control that that's the way that they did it. But what the justices on the Supreme Court can do is make sure that they analyze just the issue that has been presented based upon the law as has been established, giving honor and respect to the spirit of the law and to the letter of the law. Now, on these issues where there are competing rights that are involved in an issue. It depends also who the litigants are. If one of the litigants is the government has the responsibility of showing a compelling state interest to infringe upon somebody's individual right. So the way that this question was sort of framed was that balancing environmental rights and freedom and financial stability. So if the individuals are the ones who are claiming that their right to financial stability is being hampered by some sort of governmental action, it's going to be incumbent upon the government to establish that compelling state interest that shows that they have to override the individual rights to financial stability that are being raised by the other litigants. If the litigants are people against people, so you don't have the government involved in it, the analysis is still, so you have to weigh, you have to consider the facts that are presented in the case. You have to consider what the damage to each of the litigants is going to be in comparing which right it should prevail if different rights are being raised. The thing about the law that is beautiful is that I feel so honored to have had 39 years involved in the law because it is never boring. It's always interesting. You get to hear from really intelligent people, different arguments and things. But as a judge, you have to limit what you are deciding to those arguments that are raised, to those facts that make their way into the record, and to the law that people before you already decided. You have to have the humility to know that there were others who were part of the cogs in the system of developing the law as it has evolved over time. And so this whole issue of environmental rights versus freedom and financial stability is one that would require careful thought and consideration.
Thank you, Judge Bettigary. And thank you all for your answers. The next topic will be in regard to endangered species. The Endangered Species Act has been a source of litigation, oftentimes the hands of those that live and work in critical habitats and preventing state management of species like grizzly bears. As of 2023, over 1,700 species have been listed as threatened or endangered. Of those species, only 56 have been delisted, despite what a Fortune magazine article cites as nearly $1.2 billion allocated to the efforts annually. Montana Farm Bureau has been advocating for the delisting of several species, including grizzly bears, since 1997. Your question is, what can Montana and our court system do to ensure that the species remain viable and that the delisting process can proceed as intended by the Endangered Species Act when needed? Once again, 3 minutes each. Judge Bettigary.
So on our farm and ranch, we always had to worry about the coyotes. And we had aerial coyote hunters that regularly helped us keep the coyotes at bay. As far as this issue of the Endangered Species Act, it's a federal law. And the way that the law works is that the United States Constitution is the supreme law of the land, and the United States Supreme Court is the arbiter of that document. The United States Constitution gives citizens basic rights, but each state is allowed to give its citizens additional rights, and our 1972 Montana Constitution does that. The Endangered Species Act being a federal law, if it conflicted with anything in Montana law, we'd have to give deference to federal law. So most of the time, I think that law is invoked in a federal, in the federal judiciary rather than the Montana Supreme Court. Regardless of how the issue is raised, however, again, it really matters what evidence is presented in the particular case that a judge is deciding in terms of what the outcome would be. We can't control what the attorneys or unrepresented litigants will present to us and put into the record. But we are committed and have the duty to base our decisions based just on what facts were brought into the record. The courts, in having to address the Endangered Species Act, would have to ensure that decisions are based on science and whatever evidence was actually presented into the record, because that would help avoid any kind of unnecessary delays in like delisting species that have already recovered, and allowing resources to focus maybe on species that have yet danger. Montana courts should not be involved in the policy decision-making, but if the legislature has enacted a law that is implicated in a case, then of course the courts are going to have to consider the competing interests and how that law touches upon the people who have raised the issue. As far as farmers and ranchers are concerned, hopefully when the legislature makes laws that address its species and what farmers and ranchers can do about it, they will allow stakeholders like farmers and ranchers to be part of the process and to give input on what the law actually should be. Having that happen goes a long ways toward helping the courts that have to interpret and apply those laws, apply them correctly.
Thank you, Judge Bettigary. Mr. Swanson, you're next.
Well, I just want to point out that if you look at the process of how we dealt with wolves, so when you hit a point where the wolves are delisted to the point where they're managed by the states, which happened in Montana in the last, 15 years, I'd say, then their management, their hunting, all that is under Montana law. Judge Bettigary is correct that the initial issue of whether they're just delisted is a federal decision, which is often litigated in federal court. Grizzly bears are being litigated right now in federal court. But once the issue goes to the state, then the hunting, trapping, and management of the wolves, for example, is under state law and state authorities. Well, what can we do? Well, we can enforce the law, for one. I mean, so every time that you deal with a trophy animal or a rare animal that gets poached illegally, you're kind of hurting everybody. And so as a prosecutor, I've prosecuted a number of big poaching cases, a trophy moose a couple years ago. I was trapped Monday. I filed a big poaching case of elk and deer in an area outside of Townsend where you can't get a bull tag. It's one of the hardest bull tags in the state to get, and some people killed 3 of them. So during archery season with a rifle, how about that? So with headlights, I mean, it just gets worse. So we were able to prosecute those folks. But you have to keep in mind that the state's portion of it, if we can get that portion, managing the wolves, if we get the grizzlies, managing the grizzlies, and then it requires the court system to correctly enforce those laws. So other than that, it's going to be a policy issue, it's going to be a wildlife management issue, but and really what we need is we need federal courts and federal agencies to use science that's fair, not science that's slanted, so that we can actually get a good count on. I think the one we're looking at now is grizzly bears. There's grizzly bears in the breaks. There's grizzly bears everywhere. I was just talking to a friend of mine who's a lawyer who's working on this, who is saying they're not connected. So the environmental groups are of course going to challenge any delisting. That's going to be a federal issue. But if it comes to the state, then the state needs to correctly manage it so it doesn't get taken back out of the state hands to the feds.
Thank you, Mr. Swanson. Judge Wilson?
When the Supreme Court doesn't have any business making a decision, it should acknowledge that fact and stay out of the way. And stay out of the dispute. This is not a question for our Montana Supreme Court to weigh in on. It is an issue that affects us all. It affects us all personally. I could be called as a witness at a hearing, and I would testify from my personal knowledge that my in-laws farm and ranch that's barely 20 miles outside of Kalispell has this year about 6 resident grizzly bears, and they are feeding themselves even through locked handles occasionally on the grain in the storage bins. And so it's quite something, and it's not something that anybody's inviting. Trash is kept indoors. It's not stored outside in containers to get the bears. They put big fences around all the beehives in the wintertime to keep them out. But, you know, it is an issue, and it's one that affects a lot of Montanans, and it affects ag people, I think, more than anybody else. If you look at that area around Kalispell, it's just about all houses now. Just a few places around the river and such where bears can make their way in and out, but they seem to be doing it quite comfortably, and they're getting pretty big on that grain too. So Short answer, Supreme Court, if it's not your business, keep out of it. And if I were on the Supreme Court, that would surely be my assessment of the issue.
Well, thank you, Judge Wilson. And thank you all for answering our questions. Now, each candidate will have 2 minutes to give their closing statements, and it will be the same order as the opening. So, candidate for Chief Justice, Corey Swanson, if you'd like to start.
Well, thank you, and thank you all for coming, and thank you everybody out in the radio land that's listening. I hope this debate has helped you to get an idea of who we are as candidates. We are near the end of this campaign. Absentee ballots are going in the mail. I think tomorrow people can start voting. Some have already started voting, but you can definitely start voting by Friday. And if you are sick of mail, if you vote your absentee ballot and turn it in, people that are good at mail will stop sending you mail because they'll keep track of the fact that you've turned in your ballot. So maybe that's vote early, and maybe you'll get rid of the junk mail that's coming to your home uninvited. I would just appreciate your support because I believe that the Montana Supreme Court, it's going to be changing over. Really, I think most members of the court, if not all members of the court, are going to turn over in the next 6 to 8 years. And really what we want to focus on for our future is we want to focus on a Supreme Court that is determined to be fair and unbiased, no matter what type of case it is, no matter who the litigants are, no matter how either mundane and boring the case may be, or no matter how controversial and well-publicized the case may be. That's my goal. That's my commitment to you, that I will use the exact same methodology, clearly committed to understanding the facts of each case and to give you my best interpretation, my fair and unbiased interpretation of the law for every single case. Along the way, my goal is to reduce the political fighting that's going on in Helena right now among the branches. A lot of that conflict is unnecessary. A lot of that conflict we just want to put in the rearview mirror so that you have confidence the Supreme Court is there doing your business, not getting messed up in political fights that seem to have no end. Because we want an end of the political fights, and we want to just simply get back to the lawyer fights that we deal with every day. Because when we do that, we believe we're going to be doing your business, giving you the fair, predictable, reliable law that you can count on, so you can go about your life not worrying about the Supreme Court messing it up on a daily basis. Thank you.
Well, thank you, Corey Swanson. Next, we'll hear from Judge Dan Wilson.
Thank you again to the Farm Bureau. My family background is in agriculture. My great-granddad homesteaded in Phillips County in 1913. My folks grew up in Malta. And running this race, it was not my intention from the outset, as I've said, primarily to attack my opponent. I've been asked questions by newspapers and others. How does your judicial philosophy differ from your opponent's? And I have answered, I will tell you what my philosophy is, but I'll respect my opponent, who's also a district court judge, and allow her that privilege of defining her philosophy. This race has turned out to be one where my biggest opponent is dark money spending. And I found out today that the person behind the attack ads claiming that I'm trying to end public access in Montana to public lands is a New York City billionaire who wrote a check that for him is pocket change, about $750,000. But he doesn't know me, and they can't find anything I've ever said or done that indicates that I'm against public access. They merely attack me because I've accepted money from the wrong people. Well, how about that? This billionaire doesn't know me. I don't know him. If he claims that I'm against public access, he wasn't with me, with my grandpa when he taught me how to fish without a bobber on the shores of Nelson Reservoir in Phillips County, Montana in about 1968. And he wasn't with me when I floated the river, Gallon River, with my dad, or when I hiked up to Mount Aeneas with my daughter and showed her the magnificent view. And he wasn't with me when I volunteered and remade trails and expanded trails in the state park, along with some other volunteers. The truth is that this race is one that I'm fighting against special interests, not necessarily against my opponent. But what I've been dealt and what is unfair is this is just a New York City sucker punch from a New York City billionaire. So take my word for it. I didn't run for the Supreme Court and public access. I treasure it as our rightful heritage.
Thank you, Judge Wilson. Judge Catherine Bettigary.
I'm a stronger candidate for seat number 3 on the Montana Supreme Court because of my extensive experience, unwavering impartiality, and my commitment to upholding the law. With 39 years of legal experience, which includes 21 3/4 years as district court judge, I have consistently demonstrated the qualities needed for this role: decisiveness, patience, collegiality, and a well-honed ability to analyze complex legal issues. My work has covered a wide range of cases, including property and water law, which are critical to rural communities like ours. This experience has sharpened my skills in listening, writing, and applying the law fairly and impartially. Growing up on a farm and ranch in eastern Montana taught me the importance of hard work, integrity, and perseverance, values that I have carried with me throughout my legal career. My background gives me a deep understanding of the diverse perspectives across our state, from agricultural communities to urban areas. I firmly believe that no one is above or below the law, and that all Montanans deserve to be treated fairly by a neutral and independent judiciary. This commitment to impartiality and consistency in applying established precedents is the foundation of my judicial philosophy. I know that there's this, what my opponent just said about the backing or the attack ads by some billionaire in New York, but my opponent is backed by a political party that already controls both the legislative and executive branches. I'll remain independent and free from partisan influence. Those seeking to consolidate all of the power in government across all 3 branches know they cannot sway me or control me. I'll base my decisions on legal reasoning and the facts, ensuring that both the U.S. and Montana constitutions are followed. I'm dedicated to preserving the separation of powers, which is essential to protecting the rights and freedoms that every Montanan is entitled to expect and deserves. As your Supreme Court Justice, I will bring the independence, experience, and dedication needed to keep politics out of the courtroom and ensure justice for all.
Well, thank you, Judge Bettigary. So I want to thank you all for coming here tonight. I also want to thank everyone who is tuning in and listening to us on the radio. Montana Farm Bureau, and especially Yellowstone County Farm Bureau, are proud to help you access information to the candidates. We hope that this has been helpful. Don't forget to cast your ballot on November 5th. And hopefully, as Mr. Swanson says, that you can stop getting get the mailers. If you want to support more efforts like these or get involved at the local level, you can join the cause at Montana Farm Bureau, mfbf.org/join, or donate to the Montana Farm Bureau PAC. So it's Montana Farm Bureau. We care for the country. Thanks again.
Nice job, you guys. I